Yes, sir.
Good morning. All this meeting is called to order. Mr. Troman, is anyone signed up for public comment? Thank you, Mr. Troman. Here we are. Good morning. All right, no cases to reconsider under agenda item 3.
Yes, sir, that's
Is that
correct.
correct? Let's consider tax liability. No, we don't have any tax liability cases on docket 9.
That's correct, sir.
No fair housing cases, no child labor cases, no wage claim cases pulled for additional discussion under agenda item 7.
Yes, that is correct, sir. But you should have received the wage claim short form dissent list for docket 9.
I move we accept staff recommendations on the remaining wage claim cases on docket 9.
I second the motion, except for those cases in which I am dissenting, as reflected on the wage claim short form dissent list for docket 9.
I concur with the chairman's motion, except for the cases in which I am dissenting as reflected in wage claim short form dissent list.
Motion passes with the exceptions noted. Let's move to agenda item 8 and consideration of unemployment insurance cases on docket 9. Please proceed when you're ready.
Right.
Case number 2965251, Commissioner Esparza.
We should affirm the AT decision first. I do not contest that the claimant established good cause for missing the AT2 hearing or that the claim was valid. Concerning AT1, although the claimant was aware of the date and time of the scheduled rehearing, she refused to participate by contacting the hearing officer prior to the start of the hearing to state her displeasure about having to attend a hearing prior to being eligible for benefits. Since the claimant was aware of the time and the date of the scheduled hearing, but thereafter refused to participate, she did not establish good cause. As such, we should affirm the AT decision. The claimant established good cause for missing the AT2 hearing. The claimant did not establish good cause for missing the AT1 hearing, valid claim, voluntary leaving. And the alternative, even if the commission finds good cause, and the claimant should be disqualified from benefits. The claimant quit based on generalized fear of contracting COVID-19. Claimant did not inform the employer about any medical ailments, nor did she provide medical documentation with which evidence that she should quit. Since the claimant quit based on generalized fear when continuing work was in fact available, the claimant's resignation was voluntary without work-connected good cause. As such, we should modify the AT decision. Claimant established good cause for missing the AT2 hearing. Claimant established good cause for missing the AT1 hearing. Valid claim, voluntary leaving.
The decision is not supportable. First, I agree that the claimant had good cause for missing the AT2 due to the unexpected phone problems. Regarding the issue of the claimant missing AT1, the hearing was not scheduled until over a year after the initial determination, and the claimant did not participate due to personal illness. Therefore, the claimant had good cause for missing AT1 as well. As for the job separation, the claimant left the job during the height of the COVID pandemic due to underlying health issues, which she verified through medical documentation. That left her at high risk for being exposed to the virus. Therefore, the claimant leaving the job was due to medically verified illness. Modify the AT. Claimant had good cause for missing AT2. Claimant had good cause for missing AT1. Valid initial claim. No voluntary leaving. MVI.
Claimant established good cause for AT2 and AT1. Valid claim, voluntary leaving.
We have a majority vote of good cause at 81, good cause at 82, valid claim, and voluntary leaving.
Short form dissent.
The short form dissent is noted.
Case number 3157911, Commissioner Esparza.
We should affirm the AT decision since the overpayment was premised on the work separation arising from case number 2965251. The claimant's disqualification in that case should render the overpayment decision in this case to remain in full force and effect. As such, we should affirm the AT decision overpayment.
The decision is not correct, since the overpayment at issue in this case is a direct result of the work separation disqualification at issue in the companion case, case number 2965251. And since the disqualification in the companion case should be reversed, the overpayment in this case should also be reversed. Reverse the AT, no overpayment.
Overpayment.
Short form dissent, ma'am.
Short form dissent is noted.
Case number 3111870, Commissioner Esparza.
The AT decision is not supportable. The original notice of the maximum potential chargeback was mailed to the employer during the pandemic, time when most restaurants, including the employers, were still shut down, and TWC and postal systems continued to be overwhelmed. The employer's late response to the NMPC, its late appeal to the appeal tribunal, and its late appeal to the commission were all attributable to COVID-related mail issues. Also, the lingering effects of the pandemic shutdowns and the inconsistent misleading messages that it received from TWC at the time concerning the need to respond to chargebacks notices or to appeal. Information about the chargeback issue is not yet in the record before the commission. Accordingly, we should reverse the AT decision. The employer filed a timely appeal to the commission. The employer filed a timely appeal to the appeal tribunal. The employer filed a timely protest to the NMPC. Resubmit on the chargeback issue.
The employer's appeal to the commission should be dismissed as late. At the rehearing on the timeliness issue, the employer offered inconsistent testimony about whether it received the AT decision in the mail or whether they lost track of their own mail. Therefore, the employer did not meet the credible and persuasive standard required to rebut the presumption of receipt and did not otherwise establish any explanation that would constitute any exception to the timeliness rules. Dismiss the employer's CA appeal as late and leave the AT decision in full force and effect. Late employer appeal, late response to notice of maximum potential chargeback, charge the employer's account.
Late commission appeal, the AT decision remains in full force and effect.
Short form dissent.
We have the short form dissent.
Case number 3122501, Commissioner Esparza.
Read that number again for
Yes,
us.
please.
3125011, Commissioner Esparza.
Thank you. The AT decision is not supportable due to misleading and inconsistent information from TWC regarding the need to respond to chargeback notices and to file an appeal. The employer's chargeback notice response and its appeal from the chargeback determination should both be considered timely. Concerning the chargeback issue that is not yet in the record before the commission, we'll need additional evidence concerning that issue. Accordingly, we should reverse the AT decision. The employer filed a timely appeal. The employer filed a timely response to the NMPC and resubmit the case on the chargeback issue.
The AT decision is correct. Although the employer may have initially received TWC misinformation regarding their need to file a response to TWC documents, the employer was informed of their need to respond prior to the issuance of the TWC document on January 14th, 2022. Therefore, the employer has not established any exception to the timeliness rule in this case. Affirm the AT, employer appeal not timely, late response to the notice of maximum potential chargeback, charge the employer's account.
Timely employer appeal, resubmit.
We don't have a majority vote. Commissioner Esparza voted timely AT appeal, timely protest to the notice of maximum potential chargeback and resubmit. And Chairman Daniel voted timely appeal and resubmit.
If I could request a clarification, please. I believe the distinction is, Mr. Chairman, that you did not provide a vote on the late response issue. So we don't have an agreement as to whether the majority right now is only on the late appeal issue or whether it's on the late appeal and the late response issue. So we have one vote that both are timely and resubmit. The other vote is that the appeal is timely and resubmit on late response and chargeback. So we need to come to agreement on the late response issue.
That's the late response to the NMPC part, right?
Right.
Okay. My vote was timely response.
Yes, sir. And Mr. Chairman didn't make a vote on that. He's
Okay.
voting to resubmit on that issue.
Give me one second.
Yes, sir.
Case number three, four.
My apologies.
I
I'm
apologize.
going to support the chairman and resubmit.
So the majority vote is timely appeal and resubmit on both the notice issue and the chargeback issue.
That's correct.
Yes, we'll resubmit. Thank
Okay.
you.
Thank you for the clarification on that.
Yes, sir.
Case number 3419823, Commissioner Esparza.
The AT decision should be affirmed with regard to the good cause issues, as both parties had good cause for their non-appearances. However, as to the underlying merits, the commission should grant a rehearing in this case. The events that led to the claimant's job separation are clearly in dispute by the parties. The claimant denies wrongdoing. However, the employer provided testimony that it witnessed the claimant shouting at customers on video, and then another person witnessed the claimant throwing things firsthand. As such, we should affirm that we should affirm that part of the AT decision that held both parties had good cause for their respective non-appearances, but we should rehear this case with regard to the underlying merits so that the employer can provide both their video evidence and testimony from its firsthand witness.
The AT decision should be modified. I agree that the claimant and the employer both established that they had good cause for missing the prior hearings. However, regarding the job separation, the claimant has provided consistent and credible testimony denying the allegations of misconduct, while the employer testified based on viewing a video that was not offered as evidence. Therefore, the employer failed to provide sufficient evidence to establish that the claimant was discharged for misconduct connected with the work. Modify the AT. Claimant established good cause for AT2. Employer established good cause for AT1. No misconduct, chargeback.
Claimant established good cause for AT2. Employer established good cause for AT1. No misconduct, chargeback.
Short form dissent.
We have the short form dissent.
Case number 3518956, Commissioner Trevino.
The AT decision is not supportable. The claimant had returned to work prior to the AT1 hearing. Though the claimant had obtained permission to take time away from his new job to participate in the hearing, he became busy with work and could not participate. Claimant should not be penalized for returning to work. Therefore, the claimant has established that he had good cause for his failure to appear at the prior hearing. Reverse the AT. Claimant had good cause for AT1. Resubmit.
We should affirm the AT decision concerning good cause. Although the claimant had permission to attend the AT hearing, he did not attend because he forgot about the hearing and called in late. Since the claimant was not prevented from attending the AT hearing due to circumstances beyond his control, he did not establish good cause. Concerning the merits, the claimant was terminated when he threatened to be less productive unless the employer provided him with a pay raise. Since the claimant behaved inappropriately to obtain a raise, the claimant mismanaged his position of employment. As such, we should affirm the AT decision. Claimant did not establish good cause for missing the AT hearing. Misconduct, no chargeback.
Claimant established good cause for AT1. Resubmit.
We will resubmit the case.
Case number 3575627.
The AT decision is not supportable. The claimant was hired as a remote worker and performed her work off-site, though she often came into the office for meetings. The claimant was not able to meet the employer's performance expectations and was told she either needed to begin working in the office full-time or she would be terminated. The claimant was given very little time to make the decision and to arrange for transportation, childcare, and other issues. The claimant did not accept this change in her hiring agreement and was therefore terminated by the employer. Since the claimant was terminated for refusing to accept a change in her hiring agreement, the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The AT decision should be affirmed. The claimant was provided the option to continue her employment, but under the condition that she worked on-site as opposed to working remotely. The claimant was already traveling to the employer's work site for one-on-one meetings, so the change for her to work on-site would not have constituted a material change to her hiring agreement. Nonetheless, the claimant decided not to pursue the employer's offer of working on-site. Because continuing work would have been available to the claimant had she not resigned, and because there is no evidence that working conditions would have been intolerable, the claimant quit, the claimant quit without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Voluntary leaving, no chargeback.
Short form dissent.
We have the short form dissent.
Case number 3577404, Commissioner Esparza.
We should reverse the AT decision. Prior to the date of the initial claim, the claimant failed to return to work for the employer for the new school term, despite having received and having signed a letter of reasonable assurance. The employer intended the working relationship to continue into the following school year. Similarly, the claimant represented to the employer that she planned to return. By failing to return to work as expected when school reconvened, the claimant initiated the job separation. Since there is no evidence she had good cause to quit, we should reverse the AT decision, reimbursing employer not billed.
The decision is correct. The claimant worked as a substitute teacher on an as-needed basis. The claimant last worked for the employer in May of 2022, and then stopped working because the school year ended. Although the claimant did not return to substitute teaching when the following school year started in August, her separation occurred in May when there was no further work due to school year ending. Therefore, the claimant's work separation was not for any disqualifying reason, and the employer's account is subject to being billed. Affirm the AT, bill reimbursing employer.
Reimbursing employer, not bill.
Short form dissent.
The short form dissent is noted. That was the last case pulled for additional discussion on docket 9, and you should have received the short form dissent list for docket 9.
I move we accept staff recommendations on the remaining UI cases on docket 9.
I second the motion except for those cases on which I am dissenting, as reflected on the UI short form dissent list for docket 9.
I concur with the chairman's motion, except for the cases on which I am dissenting as reflected in the UI short form dissent list for docket 9.
Motion passes with the exceptions noted. Is there any other order of business come before the commission? Is there a motion to adjourn?
Second.
Been seconded to adjourn, and we're adjourned.
Record?